Unmute. Deepak.
Now can you hear me?
Yes, sir. Yeah. Now we can hear you, please.
Sir, I am Deepak, Chairman of the Association of Consulting Civil Engineers, Mysore Center, sir. Ellarigu namaskara. A very good evening to you all. I, on behalf of ACCA Mysore Center, in association with Ramco Cements, welcome the members of ACCA of all centers, invitees, participants, and friends to the much awaited webinar on mediation, where both parties win. I, on behalf of Mysore Center, welcome one of the speakers for this evening, Sri B. Rangaraju, Senior Mediator, Singapore Law Society, International Mediation Institute. I welcome you, sir.
Thank you.
And another speaker, Engineer P.M. Nagesh, Director at Chambers International Private Limited. I welcome you, sir.
Thank you.
I will also welcome Engineer Vijay Sanap, National President, ACCI, and Vijay Sanap, are you there? Secretary General, and Raj Kumar, Vice President, South. And I also welcome Engineer Anil Pillai, GM, Technical Service of Ramco Cements, who is moderator for today's evening program. I also welcome Engineer Niranjan Simha, Advisor L&T for this webinar. Welcome you, sir. I just take few minutes. I'll brief about the ACCA Mysore Center. Mysore Center was instituted on May 2001 with 20 members and currently has 200 members. As you all know, we at the Mysore Center of the Association of Consulting Civil Engineers have been in the forefront of knowledge dissemination through various workshops, seminars, project site visits. Since its inception, the association has organized many technical programs and workshops to keep the webinar members updated about the technological developments in the field of civil engineering. It has also conducted major events: 2-day national seminar on long span bridges in 2004, 1-day national workshop on water and waste management in 2009, 2-day national seminar on steel structures, 1-day workshop in recent advancement in geotechnics in 2014, 2015, and 2016. Now it is being held biennially since 2018. 2-day biennial national conference, recent advances in civil engineering, that is RACE in 2017, 19, and 21. Engineers Day celebration since 2013. Annual awards for outstanding residential villas and commercial buildings constructed in 5 districts in association with Ultrac Cements since 2014. And Design Safe and Best MTech award programs for MTech students since 2014. We have been offering 1-day industry outreach program from past 4 years for the final year BE students of civil and CTM branches of various engineering colleges in Mysore, where we teach the important practical aspects of construction. We have been responding to the needs of the society in crisis as well. We have contributed materials to the landslide victims in Cure during 2019 and also during the first and second wave of COVID, and also donated kits to the doctors of JSS Hospital. This apart, the center has organized a number of other technical programs, project visits, and family get-together. In this current year, where pandemic had slowed down, we had conducted Environmental Month, and we visited Rishi FABC factory near Gundupet, and also visited a number of construction sites. We celebrated Engineers Day in the month of September. We visited the construction of Mysore-Bangalore 10-lane highway project. Now we have planned to have ACC Ultratech Awards night this month, Design and MTech Thesis Award in February, Ragi in month of March 2022. Finally, I wish to state that ACCA Mysore Center bagged 5 awards during last year, which include the Best Center Award, Best Active Center Award, Most Active Center Award, Best Institute Relationship Award. Once again, I welcome you to all this seminar. Thank you, sir.
Thank you, Engineer Deepak.
Now we can.
So I think we just make some adjustment.
You can mute.
But the problem is that if you mute some, no, it is everybody is getting muted. That's the reason. Okay.
Oh, okay.
Yeah. Good afternoon to all of you. In fact, this is one of the first major programs during the onset of the new year 2022. And I am sure that programs of this kind would be online because seeing the situation, we would have to have it online. I'll just mute everybody.
Yeah.
Yeah, now it's okay. Yes. So the thing is that this kind of programs, I'm sure that we would have an opportunity to listen to the experts, and we would also, this is also an opportunity to further our knowledge in various areas. Now, today's topic, mediation as a part of redressal of various conflicts, I'm sure would be of interest to all the construction professionals, because when we execute a project, we have number of differences of opinions which can come up because of the sheer number of stakeholders that is going to be there in the project. So by virtue of that, I'm sure that we will have to see how this can be redressed. So I'm sure that the experts who have come here would throw a lot of light on this, and all of us will get benefited by this. Ramco Cements, as all of you know, we have been in the forefront of organizing such kind of events so that all of us come together, share information on various kind of constructions, various kind of challenges that we are facing, so that we get a better idea and we are prepared to face them, and at the same time arrive at a solution so that all of us get benefited from it. So this kind of programs we have been conducting, and we have also been in the forefront of customizing products based on the applications. So we have various products for various applications ranging from concrete to plastering to various other problems that the construction professional is facing from the material perspective. So we are open to any kind of suggestions from the professionals. Now we are also having this collaboration with the Association of Consulting Civil Engineers for quite a long time, and we have been organizing various kinds of meetings in collaboration with them. So today we are happy to have the dignitaries from other countries, from Singapore, and we are also very happy to have the office bearers from Association of Consulting Civil Engineers, especially Mr. President of the Association of Consulting Civil Engineers, who is there with us. So let me take this opportunity to introduce him, Engineer Vijay Kumar Sanap, who is there with us. He graduated from Pune University. He started his consulting engineering practice in 1996. He's having a multidisciplinary award-winning firm engaged in architectural, structural, interior, and project management services. He's continuously involved in all decision-making process for a city, a dynamic person who places ethics over everything else. He joined ACCEI in the year 2000. He served as managing committee member of Nashik Center from 2001 to 2013. He served as chairman of Nashik Center for 2 consecutive terms from 2013 to 2017. He was vice president West for ACCI from 2017 to 2019. He was governing council member for 5 consecutive terms. He was instrumental in organizing many national events with Nashik team like Infra CE 2012, Build Mat Tech 2013, Infra CE 2018, Orientation and Leadership Programs 2019. In this year, he has been elected unopposed as a national president of ACCE India. He is the youngest president of association till date. After he took over as president of ACCEI, membership strength increased by 30% and number of centers grown by 33%. He is young, dynamic, and known for his innovative ideas and leadership. So let me take this opportunity to invite him for this meeting and share his valuable thoughts. So let me just, I think, yeah, you can unmute yourself, President. Yeah, thank you so much. Yeah,
thank you. Thank you, Anilji. Thank you for wonderful introduction. Thank you so much. And I'm really happy today that Mysore Center is conducting a wonderful event. They have invited B. Rangaraju and PM Nagesh from Singapore. And it's really a treat to listen to these kind of stalwarts in their field. And I'm sure all the members of an association, especially Mysore Center, are going to enjoy from these kind of events. And I really congratulate Deepak for his wonderful work as a chairman for Mysore Center and his entire team. Actually, physical meetings are now a rare possibility due to COVID. We are living in new normal, and I'm sure this COVID will really be relaxed soon, and we'll meet physically. But till then, let's have an online meetings, knowledge dissipation, and let's not stop here. Let's have a continuous online meetings, online lectures, seminars, and continue this knowledge dissipation with the help of Ramco and other sponsors. I'm really thankful to all of you to invite me here for today's online session. And I wish you all the best and see you very soon physically in Mysore. Thank you so much.
Thank you, President Engineer Vijay Sanath, for that opening remarks. Now, let me request Engineer Niranjan Shima, Advisor L&T, to introduce today's key speaker, Mr. B. Rangaraju. Over to you.
Good afternoon to all of you, and thank you for this opportunity. First of all, wish each participant a very happy, joyous, peaceful, and safe, healthy New Year 2022. The topic for today is mediation, where both parties win. What is mediation is the key issue that comes up. Basically, it is a voluntary process where a neutral third party, very important to note, it's a neutral third party, whom is called the mediator, facilitates the disputant's negotiation process for a private and amicable settlement. It is fast, it is amicable, it is used in all over the world in resolving of various disputes, be it in supply of goods, services, construction, infrastructure projects, partnership deals, banking, finance, insurance claims, domain name disputes, etc. Coming particularly to infrastructure projects, these are high value, and in the requirements of today, they are in a relative shorter time frame. When issues arise from such projects, and it is obvious since many parties are involved, we have differing opinions for resolving the issue. And what we need is someone with the requisite knowledge of technical as well as the commercial side, who understand and find a via media or an in-between, or what we call a mediating solution, so that such disputes are resolved very expeditiously and the result in that project being on time. If projects don't get these kind of problems resolved on time, we know that they tend to have cost overruns, time overruns, also expectation issues and things like that. Even within on the construction side, disputes between contractors and subcontractors can also arise, and this can also be a impediment in good project execution due to unclear contractual terms. It could be project delays. It could be them not resolving their individual responsibilities, be it in terms of drawings, could be in terms of front availability, also it could be in terms of finances or resources. And what happens is these issues tend to get protracted, and these result in cost delays or time overruns. The need of the hour is to find solutions which are fast, which are effective, and which suit the project in time of its overall cost and time parameters that is in. So it is with this respect, we thought we'll invite an expert mediator, Mr. Rangaraju, to share with us his knowledge on mediation, particularly with respect to the Singapore context. Mr. Rangaraju graduated with a Bachelor of Laws degree from the University of London and was admitted to the bar in England and Wales as a barrister before being admitted to the Singapore bar. He subsequently obtained a master's in law from the National University of Singapore. He is a chartered arbitrator and a SIAC and Chartered Institute of Arbitrators panel arbitrator. He has sat as an arbitrator in domestic and international commercial arbitrations, and he specializes in hearing disputes arising from international trade under various arbitration laws and rules. Besides arbitration practice, Mr. Rangaraju has mediated a number of commercial disputes as a principal mediator of the Singapore Mediation Center. He is a certified mediator of the Singapore International Mediation Institute and a senior mediator on the panel of Law Society Mediation Scheme. He has significant mediation experience, has dealt over 200 cases, right from Singapore Law Society Mediation Scheme, Consumer Association of Singapore, and so on. He is an International Mediation Institute certified mediator, as I said, with a current 80% success rate. So, it all boils down to ultimately what comes out of the mediation. He is also on the Council of Estate Agencies Discipline Panel and sits as the chairman and a member of the Discipline Committee since 2015. He is a recipient of Outstanding Court Volunteer State Courts Award for the year 2020. Without me spending much time on anything further, I would now request Mr. Rangaraju to share his thoughts, his views, and what mediation could mean for the future of construction. Over to you, Mr. Rangaraju.
I will make you the host, Rangaraju sir.
Yes.
I will just you have a presentation to share, right?
Yes. We'll start that.
Just give me a couple of minutes. Just check. Have I made you the host?
Let me check. No, still disabled.
Still disabled. Okay. How about now? Yeah, now
Yes,
we can.
yes.
So I would request all the participants to reserve their questions towards the end of the presentation of both the keynote speakers. You can just make a note of it, or you can share it in the chat section. And at the end of the session, we would be taking all the questions. Thank you so much. Over to you, Rangaraju sir.
Thank you so much, Anil. And thank you so much, Niranjan Simha, for the kind introduction. And in fact, Niranjan Simha has taken over my job by summarizing what I'm going to say this afternoon or this evening. So what I'm going to do is just going to enlarge what Shima has said earlier. Good afternoon, gentlemen. Mediation is something that is quite close to my heart. And I have a passion for this, in fact. So from that, let me take you through. The Honorable Mr. Justice N.V. Ramana, the Chief Justice of India, Supreme Court of India, in his speech delivered at the India-Singapore Mediation Summit in 2021, has shed some light on the current state of mediation practice in India. His Honor observed there were 43 mediation centers in India, and the data suggests that there were 3.22 million cases had been referred for mediation since 2005. 1 million of these cases were settled by mediation up to March 2021. It is not clear from this data how many of these cases related to construction engineering industry. Nonetheless, it is undeniable fact disputes exist in every industry that require to be resolved by one of the main dispute resolution mechanism. In this regard, seemingly, India has made some inroads in resolving dispute by mediation. Courts have been the first port of call for resolution of any disputes, despite there being other dispute resolution mechanism in place and commonly known as ADR, alternate dispute resolution, and also referred to as appropriate dispute resolution. The latter may be correct description of the various ADR, considering the process. The various dispute resolution mechanism in most jurisdictions will fall under any of the following dispute resolution mechanism. Basically, litigation, arbitration, adjudication, neutral valuation, med-arb, that's mediation arbitration, conciliation, mediation, negotiation. Now, let's, I think there's really something. Okay. Now, we will look at some main and frequently used dispute resolution mechanism that features in many jurisdictions, irrespective of whether common law jurisdiction or civil law jurisdiction, namely litigation, arbitration, conciliation, and mediation. Now, as you all know, litigation has been in place since the beginning of modern commercial activities. Courts are, the litigant takes his case too. In most jurisdictions, jurisprudence is developed by the courts. Are courts the best form for all disputes? The proceeding in court is open to the public. The judge hearing the matter may not be familiar with the working of the industry, thus requiring experts' assistance. Invariably, the case will depend on an individual judge's interpretation of the statute and evidence presented. It will take a long time for the case to be disposed of with zero-sum win-lose outcome. This comes about with great expenditure in legal cost and time, and putting an end to whatever relationship remains between the disputing parties. Now, looking at arbitration. Arbitration has come alongside with the litigation. Arbitration is not entirely a different mechanism from litigation, though it is not as formal as litigation. The arbitrator, who sits as a private judge, decides the outcome of the reference based on law and facts. The decision termed as an award is binding on the parties, just like judgment delivered in court. Arbitration has something to offer that is not available in court hearing. The hearing in an arbitration setting is private and confidential if the parties wish to do so, to be so. Clearly, it is party autonomy. The parties are free to choose the judge and arbitrator in an arbitration. The chosen arbitrator could have the expertise for the type of disputes in dispensing the need for an expert. One important factor that is common between litigation and arbitration, and this most vital factor that parties should consider, the decision is made by the trier of the case, a neutral third party, and the parties has no say in the decision-making process, unlike some other ADR mechanism. One other important attraction, besides confidentiality in the process, is the availability of a venue to enforce the awards made in one country in any of the more than 160 countries who are members of the New York Convention. You'll be wondering, in countries like, say, India, where the disputes are domestic, but it's a matter of time where Indian parties may enter into a contract with either in China or Singapore or any part of the world for providing services. And that's the time when you may consider what course of action you should consider, whether it's arbitration or litigation or any other mechanism. So it is going to be relevant, especially in the new norm. Having that in mind, as conciliation is another ADR mechanism, is somewhat similar to mediation in several aspects, but not the same. It must be noted that the distinction is not universally accepted. There's a lot of controversy, and some people still think that mediation is conciliation, conciliation is mediation. Actually, it is not the case, and let me explain that. It is common for conciliation and mediation to be used interchangeably. There are distinguishing characteristics between conciliation and mediation. The conciliator has expert knowledge of the dispute they conciliate and mediation. Between conciliation and mediation. The conciliator has expert knowledge of the dispute that they conciliate, and the conciliators, unlike mediators, may provide technical advice to the parties. The conciliator may suggest the terms of the settlement by evaluating the merits of disputes between adjudication. Without adjudication, sorry. Mediators are prohibited from giving advice or evaluating the dispute. The mediators have no advisory role. Conciliators, unlike arbitrators, has no authority to call witnesses or evidence. Hence, they do not make any binding decision or write an award. Let's look at the mediation itself now, the main topic that we're going to talk about. You can see that, as Niranjan Shima mentioned, it's voluntary, non-binding, private and confidential, without prejudice, informal, flexible. Let's look at that. With the overview of the key dispute resolution mechanism, we'll look at mediation process. The Singapore Mediation Convention had given greater impetus for mediation, not only in Singapore, but also to major economies across the globe, including India. Parties turn to mediation when parties are unable to settle their dispute by negotiation. The common method employed by everybody, negotiation is something employed by every day in everyday's life, in the daily business transaction. Mediation is not a binding process. Simply means the parties enter into an agreement to resolve their dispute voluntarily with the help of a neutral, the mediator. Like arbitration, mediation is private and confidential. Unlike litigation, mediation is informal and flexible. So if you look at that, whatever we've talked about confidential, we'll come and touch something on this about non-binding discussions. Okay. Now, as I say, non-binding is not binding on the parties unless and until both the parties agree to bound by any terms of the agreement reached at the conclusion of the mediation. Until it is signed by the parties, nothing is binding. The parties can withdraw at any time and walk out. Okay. Mediation is, as I said, it's voluntary. Parties cannot be compelled to resolve the dispute by mediation. Parties can walk away if they are not happy with the process. Mediation is not made compulsory in Singapore. In some jurisdictions, mediation is made compulsory and it's mandatory and found to be effective and acceptable. In the cities of Toronto and Ottawa, Ontario, Canada, mediation was made mandatory in 1999 by introduction of rules in the Ontario court rules. A study based on these has shown that litigants and lawyers have expressed considerable satisfaction with the mediation process under the rule. Notwithstanding this finding, not every jurisdiction is in favor of making mediation mandatory. In UK and Singapore, although mediation is not mandatory, there are rules in place to encourage parties to resolve their disputes by mediation before commencing court proceedings. There are practice directions and protocols issued by the Singapore courts for lawyers to advise their clients the benefits of mediation. Parties refusing mediation without having any good reason will be penalized in costs at the hearing, even if the party emerges as a winner at the hearing. So if it's unreasonably denied mediation, they will be penalized. They will not get the cost for which they are, for the case where they win. The other characteristics of mediation is confidentiality. It's one of the key strengths of mediation. The reason for parties to choose mediation over other methods of dispute resolution process is to keep their difference confidential, because this may have an impact on the business or the shareholders if matters goes outside and in the common domain. Generally, parties are required to sign an agreement with confidentiality clause stating information disclosed or developed during mediation will not be disclosed unless under certain exceptional circumstances when legally or morally obliged to disclose information. In mediation, there are two levels of confidentiality. One is during the joint session, where the mediator talks the parties in both the parties present. And a mediator meets one party in the absence of the other. Whatever disclosed by one party to the mediator will not be disclosed to the other party without the consent of the party who gave the information. This is to enable parties to communicate openly and freely with one another and with the mediator. At the beginning of mediation, parties also reminded that whatever discussed during mediation is also without prejudice. The term without prejudice, some may or may not understand what it means. Of course, the lawyers will know what is meant by without prejudice. Simply, it means that if something is told to the mediator or during the joint session, that party cannot use that information in the event the mediation is unsuccessful. That is, so whatever said is without prejudice. In mediation, the Mediation Act 2017 has provided an additional layer of confidentiality to mediation conducted in Singapore. Section 9 prohibits a person from disclosing any mediation communication to a third party, except for reasons provided in subsection 2 and 3. Subsection 2A to 2J provides a list of circumstances when a party is permitted to disclose mediation communication to a third party to a mediation. This is just a question of public policy. There are certain things you can't keep confidential because it affects some other people, and where these are listed in the Act, where one cannot disclose what transpires in a mediation to a third party who is not a party to the mediation. Now, the mediation has defined mediation communication, which we are talking about earlier, that it should not be disclosed, in relation to a mediation as 1, anything said or done; 2, any document prepared or any information provided for the purpose of or in the course of the mediation, and includes a mediation agreement or mediated settlement agreement. There's something good about this.
May I request Mr. Rajiv Ghosh to mute? Yeah. Yes. Thank you, sir. Please continue.
Okay. The important thing, when parties reach an agreement, especially when there's confidential, the parties don't like the terms to be disclosed to a third party. They would like to keep these terms confidential. So now the Mediation Act in Singapore provides for the confidentiality, that parties should not, is given a legal effect to the confidentiality so that parties will not disclose this. The other good thing about mediation is it's informal and flexible. You all know, unlike litigation or arbitration, there is no requirement for parties to file and serve voluminous documents. All that is required is to provide the mediator with the case summaries. You don't need to have bundles and bundles of documents for the mediator, right? The parties are free to choose the mediator, the venue and date that are suitable to the parties. Parties are free to raise any issue that is material to the dispute that may not be able to raise in litigation. Those lawyers will know that if you don't plead your case, you cannot raise it in court at the 11th hour. But in mediation, there's no such restrictions. You can raise it any new material as long as relevant or material at any time during the mediation. One other advantage of mediation, and I always stress this whenever I conduct a mediation to the parties, that they are free to decide the solution they can live with. This is something the parties will not be able to obtain in litigation or arbitration as the decision is made by the adjudicator. So parties can choose a solution that is acceptable, which they cannot get that in court or an award. It's very simple. The interest of the parties may be different. So as long as the interest is served to both the parties, they are prepared to settle and the dispute is resolved. This is something that you cannot get it in arbitration award. Even it can be delay, cost delay or liquidated damages, whatever it is. And it's also, you can have it the way you want it and the way you can live with it. Now, talking about the mediator, is an impartial person without any interest in the matter. Mediator as a neutral should treat both parties equally. His role is not to decide. In fact, when I sit as a mediator in courts, they think that as a mediator, I can decide for them. Sometimes, in fact, they will ask me, what do you think about this? What do you think about this? And that's not my role as a mediator. And I'm not there to decide, right, on the merits of the case. And he's not, because simply he's not an adjudicator, like a judge or an arbitrator. He assists the parties without giving any advice to the parties to reach a settlement. In other words, he facilitates the mediation process for the parties to resolve the dispute. It must also be remembered, he's not a conciliator. You remember we talked about it earlier, the difference between a conciliator and a mediator. So in this case, the mediator who mediates is not a conciliator to give advice and suggest terms of settlement for the parties to agree. In conciliation, you can do that. Parties can suggest terms, advise the parties, but as a mediator, you cannot do that. Now, let's look at the other important aspect of mediation, which has come into play recently. Now, based on basic contract, if parties enter into a contract, if they willingly enter into a contract, there's no problem. Generally, there should not be any difficulty in enforcing a mediated settlement. Settlement agreement, when the parties has entered into the agreement on their own volition, willingly. So if the parties enter into contract willingly and say, okay, I'll give you this, you give me this, and there shouldn't be any problem enforcing that. But you still have some parties gives problem. In rare situation, although the settlement agreement was binding, parties tend to face difficulties in enforcing this agreement. To resist enforcement of the settlement agreement, parties may raise or resort to raise some vitiating factors like duress, mistake, or any other grounds for invalidating the settlement agreement. Even you may have an agreement and parties go to court and say, you know, they can raise one of these issues to remove the liability from them or to deny liability. These difficulties have made private mediation less attractive. Such difficulty is less common in court-annexed mediation, where the matter is pending, court proceedings and settlement agreements are reached in court, is recorded as an order of court as consent judgment. So there is no problem if the matter is in court. I sit as a mediator for the courts, and that once the settlement agreement is reached, and that will be recorded by the judge or in court as a consent judgment or agreement, but which can be enforced subsequently the party reached from the agreement. Now, let's look at next one. All right, now the Mediation Act has ameliorated this difficulty to enforce the mediated agreement settlement to some extent by Section 12, which says that where a mediated settlement agreement has been made in a mediation in relation to a dispute for which no proceeding has been commenced in court. This is a situation where no proceedings in court. Any party to the agreement may, with the consent of all the other parties to the agreement, apply to court, record the agreement as an order of court. This is a very useful instrument actually, right? Now, so making private mediation far more attractive. This provision has made private mediation attractive to disputing parties to resolve their dispute through mediation without commencing a court action. You don't need to go to court. You can go straight away. There's a dispute there between the parties. You can straight away go and have it mediated by engaging a mediator. And once an agreement is reached under this section, you can have it recorded as a court order. But the application under the Act has to be made within 8 weeks of or after a mediated settlement is made. If it is applicable, application made later than, then you need the court order. Of course, this is at this point of time probably is applicable to Singapore, but I think as a matter of time, if we really look at it, probably we may have another seminar to go into deeper on the enforcement itself, because you have the mediation agreement, then you have the convention, which I will be touching on very briefly, and you have the convention itself. So there is an interplay between the Mediation Act, which in fact, you will see that the Mediation Act has been amended after the convention to include some other mediation agreements. Okay, in order to record the mediated settlement agreement as an order of court, Section 12, the mediation has to be administered. Okay, this is another important thing about to have the dispute or the mediated settlement agreement to be recorded as an order of court. The mediation has to be done in a designated mediation service provider or by a certified mediator. So as I am a certified mediator, if I mediated, of course you can get it done. You can, you can get it recorded as court order, or certified a designated survivor like SMC, Singapore Mediation Center, or somewhat similar organization, that you can get it done. Scott, I'll tell you why it may become important to India even. The Mediation Act 2017 explains what mediation is about. What is mediation is all about? You see, here, we look at this. This is not actually a definition of mediation. All it says is that mediation means a process comprising one or more sessions in which one or more mediators assist the parties to a dispute to do any of the following with the view to facilitate the resolution of the whole or part of the dispute. Identify the issues in dispute, explore and generate options, communicate with one another, voluntarily reach an agreement. If you look at this, actually, this is not country specific. Mediation is quite international. And most of mediators, whether it is UK, USA, or any part of the world, whether common law, the basic principle still is the same thing. What the mediator is going to do. So here, what the Act has done is clarify what is mediation about. Actually, it's telling you what the process is all about. Okay. Now, that's the next one. This provision is something of interest, I think, as I was telling you earlier, which may be useful to parties even in India or any other part of the world. This amendment, that the Mediation Act, if you look at Section 161, subject to Section 2, 3, 4, and 5 may not be very relevant now, applies to or in relation to any mediation conducted under mediation agreement where the mediation is wholly or partly conducted in Singapore. That may not be that important. What is important is what the amendment has done. The agreement provides that this act or the law of Singapore is to apply to the mediation. Assuming you enter in a contract to provide service to a company in Singapore, right? And you said whether it's
Can we have Mr. MVS Prasad's mic to be muted, please? Yeah, kindly mute your mic. Mr. Prasad, can you mute your mic, please?
Yeah, okay.
Yeah.
Extremely sorry, sir. Sorry.
So as I was saying, now with this act, we may say, oh, this is a Singapore Act, may not be applicable to India. It may not be the case, considering Section 161B. If your contract with Singapore party, say either that party provides you service or you provide the service or consultancy service or whatever service, probably they think, India may be cheaper to get this advice. Sorry. And enter an agreement. And if you were to insert in the agreement a clause that this agreement is subject to Singapore Mediation Act or the law of Singapore, then it will, you will get the benefit of what this act is provides, including, probably it's a bit too early to talk about this now because this is not yet tested. This was amended 2020 after the convention. So it's something this for you all to think about, how useful it can be, right? 7. Now, so as I said earlier, it's a query here. For example, a company in Singapore enters an agreement with a company in India to supply goods and services with a dispute resolution clause that provides for mediation under this act or the law of Singapore. Will the act apply? This is something food for thought, right? Okay, now let's look very quickly. The Singapore Convention, this is actually United Nations Convention on International Settlement Agreements resulting from mediation, also known as Singapore Convention on Mediation. This is something, I would say, a landmark event that happened. You all would have heard in arbitration, the New York Convention. So this is Singapore Convention, which will, I'll tell you later. In fact, India is one of the first one to sign this convention, actually. Okay. This convention has changed the landscape of mediation. What was primitive practice of resolving dispute to an international level? They brought it from primitive to an international level, this convention. This was done by providing a mechanism to enforce cross-border commercial mediated settlement agreements. So this is again, we are going back to what I said earlier about Section 61B. If it's going to be international mediation, it can be enforced, whichever part in a country who is a party to the convention. International commercial arbitration is and was popular among international commercial communities, and its effectiveness could be attributed mainly. What has happened before? This was arbitration that was popular among international community. It is simply because the enforcement provision, the New York Convention on Recognition and Enforcement of Foreign Award for arbitration that has more than 163 members countries now. I think it's now 165 or 67. This is 163 as of September 2019. There were only 12 signatories when it was open for signature in June 1958. This is the New York Convention. There was only 24. With that as a background, it would be very useful to look at SG Convention. SG Convention was open for signature on 7th August 2019. On the same day, 46 states signed the convention. As of 12th March 2020, 52 states have signed the convention. Singapore was the first state to ratify the convention, followed by Fiji and Qatar. The convention came into operation on 12th September 2020. To give effect to the Singapore Convention mediation, the Parliament on 4th February 2020 passed the Singapore Convention Act, Singapore Convention on Mediation Act. This has a foot enforcement of international mediation agreement in equal footing with the international commercial arbitration awards when come to enforcement. Let's look at some of the benefits of mediation. Okay, and this is something which has been touched upon: cost and time saving. Definitely, a mediation can even be settled in a day. When you go to court, it takes 6 months. I don't know, India, it may take even years, right? Now, you can choose a mediator of your choice. If you think A is an expert on certain area, and if the dispute is relevant to that, you can choose the mediator. And thirdly, what is really important is the control. The control is with you, with the disputants, right? So you can decide how you want the agreement to be, something that you can live with. So it's for you, it's well within your control. This is again something I always tell the parties when they appear before me for mediation. I say, look, you have an opportunity now. You decide how you want to resolve this, and you decide whether you can live with it. If you go to court on arbitration, it's taken away from your hands and you have no say in it. So that is something which I always stress whenever I sit as a mediator. This is where you can come with the creative solutions. You can think of the solutions, which you can't get anywhere else except mediation. Because as I say, the control is well within the parties and they decide what they have. And importantly, relationship. There may be a buyer and seller, there may be, vendor, retailers, they may have good relationship. And mediation is something that you still can maintain your relationship. You can resolve your dispute and you can still do business with a person. Unlike a zero-sum game where, one wins, one loses, let's end off the relationship. Whatever, once you go to the court, whatever remains, it goes out of the window, right? Now, that's the situation when there is a situation where win-win resolution. The other thing is about mediation is which I touched upon earlier. Parties will settle will agree to comply with it willingly because it's the party's willingness. They went into the thing, right? So there is no winner or loser, but both winners in mediation. But let me end summarizing what I've said in the words of Abraham Lincoln. He has said it very, the simple words. Let me just quote here. Discourage litigation. Persuade your neighbor to compromise whenever you can. Put out to them how the nominal winner is often the real loser in fees, expenses, and waste of time. Thank you.
Thank you so much, Mr. V. Rangaraju, for that wonderful presentation. In fact, you have touched upon the benefits. Now, let us hear the next speaker, and I would request all participants to go with their questions. You have the questions after the next speaker finishes his presentation. So please hold on to your questions. I am sure that most of the questions that you would be having would also be taken up by the next speaker. So let me invite Engineer M.S. Ramprasad, immediate past secretary, ACC Mysore, to introduce Mr. Engineer PM Nagesh. Over to you, Mr. Ramprasad.
Thank you, Pillai sir. Good afternoon, one and all. It gives me immense pleasure to introduce Mr. Nagesh, second speaker of today's webinar. Mr. PM Nagesh is the Director of Chambers, Singapore and India. He is a chartered quantity surveyor with legal qualifications, having 30 years of experience in construction, oil and gas and energy industries. He is a fellow of Royal Institute of Chartered Surveyors, UK, Chartered Institute of Arbitration, UK, and Singapore Institute of Arbitrators. Mr. Nagesh provides advisory and expert service in complex delay and quantum disputes. He is a qualified arbitrator and panel member of Singapore Institute of Arbitrators and Asian International Arbitration Center. Mr. Nagesh is the Director of Chambers, which is into techno-legal consultancy, specialized in contract advisory, claims consultancy, and dispute management services to construction, oil and gas, and energy industries in Singapore, India, Middle East, and the region. Chambers' cloud-based mobile, tablet, VDR applications are designed for efficient contract and dispute management to enhance profitability of its customers. Mr. Nagesh is an expert in time delay analysis of the projects and in contracts management. Friends, here I present to you Mr. Nagesh for second speakers for today's webinar. Thank you all. Over to Mr. Nagesh.
Thank you. Thank you, everyone. Thanks for generous introduction. Good afternoon and good evening. I have been involved in major construction projects in India for the past 14 years out of more than 30 years of experience. I have represented parties in adjudications by the dispute adjudication boards in FIDIC contracts, in conciliation, and also have given expert evidence in arbitration and litigation involving major delays and cost disputes, as I was told by the Mr. Ramprasad when he introduced. In addition, in Singapore, I have presented and advised parties in resolving the disputes and differences through mediation for more than 20 years. Mr. Rangaraju shared with us about the benefits of mediation in various aspects. Now, I wish to share with you my experience in some actual cases so that it helps us to see the benefit in context. For confidentiality reasons, parties and substantive matters in dispute are not disclosed. Before I talk about the cases, I wish to mention some brief statistics and introduction on mediation in Singapore. More than 5,200 cases have gone through mediation at the Singapore Mediation Center, which is in short SMC so far. Over 70% of the matters were settled, with 90% resolved within 1 day. Over Singapore dollar 10 billion, in INR terms, it is 55,000 crores worth of claims have been resolved, with Singapore dollar 110 million, which is INR 600 crores, having highest quantum in one claim to have settled. This would not have happened without the efforts of the parties, their representatives, and the mediators. When parties and their representatives enter the mediation room, either physical or virtually online, they should be prepared to settle the matter. For this to happen, representatives of the parties would have briefed and advised the parties as to what is expected of from the mediation and realistic outcome they should try and achieve, considering the time, cost, and risks involved in taking the disputes through other formal dispute resolution processes. Party representatives are required to wear entirely different hat that puts willingness to settle the matter throughout the process above the rest. Mediation advocacy skills also aligned towards that goal. In effect, mediation statements submitted by the parties to the mediator or a panel of mediators should reflect the willingness to settle in unequivocal terms. This would be entirely different from the pleadings submitted in arbitration or litigation. I have experienced this in the mediation rooms, including breakout rooms, filled with such mood and desire displayed in every action, which helped the parties and the mediator to travel together towards the win-win resolution of the dispute. I will now share few cases of interest. This case one. In this case, the court advised the parties to attempt mediation. Brief facts of the case are these. There was an accident at the project site caused by formwork collapse during concreting. I got a call from the project manager about it, and my team started to work on the notifications to the insurers about this incident under various insurance policies. While the insurer had no issue with compensation under workman compensation policy, they denied liability for material damages claimed under contractors' all-risk insurance. Insurers relied on an exclusion clause under the terms of the policy that omitted their liability for any design error. We disagreed with the insurer's position and proceeded to commence litigation in Singapore High Court as per the terms of the policy. However, the court advised the parties to try mediation first, as it felt that this matter is suitable for resolution by mediation. Parties obliged and mediation commenced at SMC. Litigation was stayed until the mediation concluded. Parties appointed an experienced structural engineer as their mediator. After nearly 10 hours of mediation proceedings, parties were able to reach a settlement. By the time the insurers were also able to get clearance from the terms of settlement from reinsurers across the globe. A settlement agreement was drafted and executed by the parties at the end of the process. Parties submitted the signed settlement agreement to the High Court, and the court entered consent judgment as agreed by the parties. This was a happy ending for both parties without affecting business relation in a fast and cost-effective manner. If this matter was not referred to mediation, parties would have spent substantial amounts of their time and money, including legal costs and appointment of experts. Also, the outcome would have been different. This is my first experience with mediation 20 years ago, and it continues until today. How's another case? This is mediation arbitration case. A specialist subcontractor claimed substantial amounts in additional payments, alleging a number of variations in scope of works in a hospital project. Parties attempted mediation first to try and resolve their disputes as required under the multi-tiered dispute resolution clauses set out under the subcontract. As an experienced quantity surveyor was appointed as mediator by SMC, as parties were unable to agree on a mediator. While the mediation process went on smoothly, it did not result in a settlement as the claimant withdrew from the process for some unknown reasons. The dispute was referred to arbitration under the rules of Singapore International Arbitration Center, in short, SIAC. In the arbitration, the respondent claimed much larger sums in counterclaims for delay damages than the claimant's claim itself. After nearly a year of full-blown arbitration and spending substantial costs in pleadings, discovery, factual witness statements, oral hearings, and closing submissions, the parties received the arbitral award that was favorable to the respondent, not the claimant, as the respondent was successful in counterclaim, resulting in the claimant having to pay the respondent, including costs. This shocking outcome for the claimant would have been completely avoided had they not withdrawn from the mediation process. Parties' timely decisions based on realistic expectations, including possible adverse outcomes in future proceedings, would have guided them for early resolution of dispute in mediation. In fact, SIAC allows and encourages parties to suspend arbitration and attempt mediation and resume arbitration if necessary in their AB-MED-AB procedure, which is arbitration, mediation, arbitration procedure. Now we look at another case. This is a conciliation matter. In a major EPC lump sum contract, the contractor asserted numerous major changes in scope of the project undertaken by them. The project was challenging technically and contractually as being first one of its kind in India. Disputes were referred to a conciliator who is a highly experienced engineer. Parties submitted their respective positions and arguments in writing and orally. Upon hearing both parties and reviewing the documents submitted, the conciliator raised a number of queries. Parties promptly responded to the queries. At the end of the process, the conciliator provided his opinion with regards to the entitlement for additional payment or otherwise for each disputed item and asked the parties to scrutinize the quantum separately. Settlement agreement along the lines of recommendations by the conciliator and the details agreed by the parties was drawn. The conciliator issued the settlement agreement for signing by the parties as formal outcome of the conciliation. The conciliator was in fact largely using mediation techniques in this case by pointing out strengths and weaknesses of each party's position in separate sessions with the parties. This way, parties were able to narrow the gap in their respective positions and resolve numerous issues. And there is another recent case which I wish to mention here. This is about a dispute under a software development contract. The employer alleged delays and deficiencies in a software developed by a service provider, who is a multinational IT company, and claimed damages, including refund of payments made. The service provider, the respondent in this case, alleged that the employer's requirements and specifications kept changing and therefore they were prevented from performing their obligations, and claimed balance payments for the work done. The service agreement provided for litigation as the dispute resolution mechanism. As a party representative, I proposed to refer this matter to mediation at SMC upon reviewing the facts and respective positions of the parties. The employer also agreed to the mediation. Currently, mediator has been appointed by SMC and the process is ongoing. If the parties are to proceed with the litigation, owing to the complex and highly technical aspects of software contract, processes, and its application, parties have to adduce expert evidence in order to assist the court. Further, it will not provide much needed confidentiality for the parties in their respective business interests. The key points with regards to mediation, in my view, is this. The pre-mediation preparation of parties by their representatives is essential. It is to set the mood and willingness to settle. Independent opinion on the strengths and weaknesses of claims and likely outcome in formal dispute resolution would be helpful in complex disputes. Costs of internal and external resources, including legal costs in formal dispute resolution, such as arbitration and mediation, also to be considered in decision making. Selection of mediator with the appropriate skills, experience, and knowledge is also an important factor. Then comes the parties' representatives who are attending the mediation should have the authority to settle. And finally, it is about drafting the terms of settlement agreement. Before I end, I would like to share with you the mediation procedure at SMC. It starts with the party filling in a form to request mediation. In case of consented mediation, both parties sign the form and submit to the SMC. If one party is initiating the mediation, then the form is submitted for the request for mediation to SMC, and SMC initiates the process and sends this request to the other party to know whether the other party is willing to commence the mediation or to be a part of the mediation or not. And if the other party agrees with it, then the mediation proceeds. If the other party is not willing to proceed with the mediation, then the case is closed. The SMC acknowledges the receipt of the request, and each party pays the filing fee. After assessment of submitted documents, SMC may call for a pre-mediation conference and or request for additional information to help parties to maximize chances of settlement. SMC advises parties on the applicable mediation fee, makes administrative arrangements, and appoints suitable mediator or mediators if not agreed by the parties. Parties pay mediation fee within the stipulated time frame and sign the agreement to mediate. Mediation happens on the designated day or days, and if the settlement is reached, then the settlement agreement is signed. So having seen the mediation in the context of various cases, and also having listened to Mr. Rangraju laying out the benefits of mediation from his personal experience as mediator for several years, and Mr. Sima outlined the issues faced by the construction and infrastructure industries that require speedy, cost-effective resolution of the disputes and differences. Now, as a consultant, I have helped my clients to enjoy the benefits of mediation. It is my duty to advise the efficient dispute resolution process that is available to my client. It applies to all the consulting engineers towards their respective clients as well. You would have noticed that in 3 out of 4 cases I have discussed this afternoon, the appointed mediators were basically engineers. Construction and infrastructure disputes involve complex technical and contractual issues. Engineers understand such issues quickly and are equipped with problem-solving skills naturally. Therefore, in my view, engineers I am the one as well, are good fit to advise our clients in resolution of commercial disputes. With the proper training and guidance, engineers could be better mediators as well. I hope and wish that new legislation on mediation taking shape in India will help businesses to resolve their disputes and differences in non-adversarial setting in mediation and grow in India and internationally. Thank you so much.
Thank you, Engineer Nagesh, for that wonderful presentation. Now I think we will open the floor for question and answer session. Many of the participants had some of this thing. One of the interesting question that was raised was regarding, can we have multiple number of mediations within the same contract? So that the work can proceed smoothly. Anyone can answer?
Yeah, I'll take that question. You can have multiple mediation in the same sitting. I have done one where I got 2 or 3 parties involved, and it can be done. That's the best thing to do, is to get all the parties involved at the same time. Yeah, you can do that.
Okay. Regarding the examples of both parties dispute and resolve with mediation mechanism, I think Engineer Nagesh has given so many examples of how the mediation mechanism can be put into practice. I think it's very interesting, and although he has covered many practical aspects as well. Would you like to add something, Engineer Nagesh, on those practical aspects? Because one of the questions is related to examples.
Yeah, I mean, there are several cases where the mediation would be helpful. It would be right from supply of goods or providing services under a service agreement, or whether it is a complex manufacturing order, or anything for that matter, which has an underlying agreement or a commercial transaction. Any dispute or differences arising out of those instruments are suitable for mediation, I think.
Another concern that was raised was that when the award is not legally binding, don't you think it's a waste of time going in for mediation? Is one of the concerns that has been raised. Any inputs on that? Because since it's not legally binding.
I can take that question.
Yeah.
I'm not sure exactly what the question is about. If it is an award, it's only done by an arbitrator. If it's an award, it's done by, you can always get it enforced through court means, right? So I'm not sure whether he's talking about arbitration or mediated settlement agreement.
So I think, as you rightly said, if it has to be legally binding, then he should not go in for mediation. Then. Because he was saying
you can get it. I was talking about the act, which gives, you can get, the agreement be, recorded as not of court. Like Engineer Nagesh has said, how after the agreement, you got it recorded as a judgment. So there shouldn't be any problem with this. That is the most important thing I was telling in my earlier speech, that the difference between arbitration and mediation, until recently, you don't have a platform or agent, for you to enforce a settlement agreement. That is where the ancestral model law, ancestral trade, ancestral convention has came out with this SG convention for enforcement of mediated settlement agreement. That is international actually. So that is what is going to make mediation very interesting and popular. Probably, I don't know, in my prediction, even arbitration may take back seat. Even arbitration is just like litigation. It can go on for years sometimes. And then, as I said, the advantage of mediation is much more than arbitration. So what was lacking in mediation was the enforcement mechanism, which has been remedied in Singapore, at least the Act as well as the Mediation Act. Both acts has addressed that issue. Yeah, hope I've answered the question.
I think Engineer Vijay Vittal had a question. Do you have to
clarify this, sir? May I clarify this? May I be permitted to clarify one more important point?
Yeah,
There's an important point like settlement agreement. See, remediation results in settlement agreement. It is a free will agreement between two parties that is more binding than the arbitration award. Arbitration award can be challenged because it is a decision of the third party, whereas settlement agreement is the decision of both the parties, a joint decision. So it is legally binding. Any agreement is as good as contract agreement, which is enforceable by law. So mediation settlement agreement or conciliation settlement agreement are legally binding. Thank you.
Okay. Question from Engineer Vijay Vittal. Do you have to include the process of mediation in initial agreement to use it if it is required?
Yes, I can take that question.
Yes, please.
Yes, it would be quite helpful. If the contract itself sets out a requirement for mediation under the multi-tier dispute resolution process, that would force the parties to mediate first and see whether they would be able to settle. That is happening. It is already incorporated in some of the standard form of contracts in Singapore. And I believe in future that would be the case in India for contracts for businesses as well.
You know that
Yes,
Engineer Nagesh has, in fact, touched on that in Singapore, where you have the ARB, MAD, ARB. So, you can go for arbitration, then go to mediation, then you can go back to arbitration. So it can be done in that way. So you can put it as correctly pointed out, you can have multi-tier clauses in that, or you can always put a clause say mediation first, failing which you can go for arbitration. It has to be stated in the agreement. As I was mentioned earlier, even the law applicable to mediation, if you put it at Singapore law or the Act, then you can have it, take advantage of the Act, 2017 Act, Singapore Mediation Act. So it is getting better. In fact, you ask me now, when it started, actually it's primitive. It's come a long way now. It's becoming one of the best. I would say personally, doing so many mediation, I would think that's you ask me personally, my personal view, is the best form of dispute resolution mechanism, where irrespective of what the dispute is all about, it can be contractual dispute, can be construction dispute. Of course, there are certain things that the law doesn't allow you, like family matters, I think, is exempted. So there are a few cases where, where you can't go for mediation. Insolvency, you can't go for mediation because the other parties are involved. So there are certain matters you can't go for mediation. Other than that, there are a lot of cases you can go for. Like, in fact, I think, Sima has earlier said, various disputes where you can go for mediation.
Thank you, Mr. Rangaraju. I think Mr. Srinivas Reddy has a question. He has raised his hands. You can go ahead with your question, Mr. Srinivas Reddy.
Yeah, I'm Srinivas Reddy from Hyderabad. I'm also an engineer and an advocate. Here, see, arbitration and mediation, they are totally different and totally different two concepts. And an award, arbitration award, is non-binding on the parties. They can escalate it to judiciary, regular judiciary. Like now we have commercial courts, appellate courts, high court, Supreme Court. Whereas a settlement agreement arised out of mediation is binding between the parties then and there. So that is the finality of the claims or the issues will attain there and then only. Later on, if the parties tend to change their mind after signing the settlement agreement, that flexibility is not there in this mediation process. Of course, India is still evolving compared to litigation. ADR, that concept is already there, alternate dispute resolution. And construction industry, it is picking up because of the complexity and the nature of claims among various stakeholders. So the Parliament is bringing up new acts in line with our international treaties, which as a government we are signing. So it is an evolving subject, and really great that this topic is brought by two eminent speakers who have shared this information. So I thought, let me have a small line of difference, distinct difference between this arbitration. As of now, arbitration is popular in construction industry in India. Maybe conciliation and mediation is more for civil disputes like matrimonial or other disputes. And as the speakers have said, there are some prohibitive subjects like crime or rental acts, or even to certain extent matrimonial acts cannot be taken in arbitration, under arbitration. Now we have to see conciliation and mediation can to a large extent will be taken up. Even CRPC, our this CPC, Civil Procedure Code has amended, bringing up a section of 89, where even in the middle of the litigation also, the judge can refer it under his prerogative for mediation and conciliation. Thank you very much.
Thank you, Engineer Srinivas Reddy, for that point. In fact, Engineer PM Nagesh has also quoted various examples from the Indian construction industry, in which he was one of the thing. I think that was very interesting. One question that has come about is from Engineer Shashikant. Is there any autonomous authority or board established for mediation or arbitration by the governments outside the court of law? Who would like to take that?
I can only.
take that.
Yes, please.
Go ahead, Nagesh.
Go ahead.
Yeah, in fact, again, I'm just taking the liberty.
Can I have Mr. Rangaraju sir on this thing, so that
the answer has been, in fact, the question has been answered by your Honorable Chief Justice himself. According to him, there were 43 mediation centers in India, which I think where they're providing service. I don't know how they're doing it, but there are institutes and centers for provision of mediation. So I think, in fact, if I recall, there are a lot of institutions, even in Kerala, I think they're having some mediation institute. I think it's cropping up quite fast. I hope I've answered the question.
Yeah. From your side, Engineer Nagesh, would you like to add something?
Yeah. For the knowledge of...
Yeah.
Okay, carry on, sir. Sorry, for the knowledge of all the participants, our Honorable Chief Justice of India has recently inaugurated an international arbitration and mediation center in Hyderabad, which is one of its kind, and a lot of judges, Supreme Court judges, High Court judges are also the members of that. I think it's a recent addition that they are looking at the international mediation at Hyderabad. That is for the knowledge of all the participants.
Thank you so much. Yeah, Engineer Nagesh, you can go on.
The question of whether there is going to be a body outside of a court of law, which is asked by Shashikant. So what I understand from the draft mediation bill is that a mediation council will be set up under this act, and then that council is to oversee various implementation of this act, including setting up of regional mediation centers and so on, in addition to probably any other mediation centers which Mr. Rangaraju was mentioning recently. Yeah. So I think, once this Mediation Act comes into effect, then this implementation of mediation will be overseen and undertaken by a separate council of mediation.
So thank you, Mr. Rangaraju and Engineer PM Nagesh. I think we have spent a lot of time, and thanks for the interaction. We invite Engineer Niranjan Shima, Advisor LLT, for his closing remarks. And yes, sir, you are there? Yes,
I'm there. Yeah. So I think thank you very much, Mr. Rangaraju and Mr. Nagesh, for a very, very informative session on mediation. You're able to hear me?
Yes, we are able to hear you.
Yeah, I mean, Mr. Rangaraju brought out the pros and cons of litigation versus arbitration versus mediation in a very lucid manner. And the key element that came out of the of his presentation was essentially meeting of minds. Ideally, when do we have the successful mediation? And a great example given by Mr. Nagesh was they did a 600 crore, if I'm not wrong, a 600 crore settlement in a few days' time of mediation. Unheard of. I mean, I've seen having come from the construction industry, arbitration typically takes 3 to 5 years, and you still go back to court from one of the parties. So, I mean, a very well thought out method, and it's great to see the government also giving an impetus to this and taking help from the government of Singapore in setting up the policy and things like that, so that whatever gets implemented here is done to the best of our knowledge. Another takeaway that I have from this meeting is many of our mediators there are consultants, are construction, and some he mentioned about structural consultants, he mentioned about construction management consultants. So this is another line. Who better to do mediation than all of us in the consulting field, because we have seen it from both the sides. You also need a certain amount of reputation and backing of understanding that what we are talking about makes a lot of sense to both the parties or to many of the parties. So I think this is one line which we could look at as another line of work. Of course, we might need some brushing up in terms of some sessions or some small, I wouldn't call it training, call it refreshers courses to tune us to the needs of mediation. And judging by what the government is doing on certain projects, even within our own country, especially on the infrastructure side, it looks like mediation is here to stay and to grow very fast. Another thing that came about was we, as consulting engineers from the group, we also have a say in framing the contract conditions with the client. And I think we could make this request to incorporate probably a scope for mediation within the contract, because I remember Mr. Nagesh mentioning that if you have it in the contract, it makes the process of mediation very efficient. So overall, I think it's an eye-opener in terms of what mediation can do. Yes, we will have issues going forward, taking it or how to implement it in government sector and things like that. But many policies have taken shape and are flourishing. Just like new technologies come, I think this is a new way of ending disputes. And what we need most within the country and for everywhere is to deliver projects fast and to the required time and cost parameters. So thank you all once again. A very great session. And I don't know if we can't do a round of applause, but well done, Mr. Rangaraju and Nagesh, and thank you all for the wonderful presentations.
Thank you,
Thank you so
Engineer
much.
Niranjan Shima, Advisor L&T, for that closing remarks. Let me, when you think about mediation and, meditation also comes to my mind because only one letter T is missing there. So sometimes, so there is some kind of, as rightly pointed out, if you have to build relationship, I think mediation is one technique whenever disputes arise. So that is one learning that has come about it. And I'm sure that in the construction industry, this can play a vital role and can save lots of money. Let me invite the Secretary of ACCI Mysore, Engineer S. Shashiraj, to deliver the vote of thanks. Over to Engineer Shashiraj.
Yeah, thank you, sir. Anil, sir. Am I audible, sir?
Yes, you are audible, sir. Please go on.
Good afternoon to one and all. I, Shashiraj, Honorary Secretary, on behalf of the Association of Consulting Civil Engineers, Mysore Center, I'm honored to propose the vote of thanks for this online webinar on mediation where both parties win. To begin with, I wish to sincerely thank the very dynamic National President of ACCI, Engineer Vijay Kumar Sanap, who in spite of his busy schedule was kind enough to accept and preside over this program. Sir, you are a source of inspiration to all of us and always support the activities organized by ACC Mysore Center. I wish to express our gratitude for being with us today and expressing your views on the importance of mediation. I sincerely thank you, sir. This webinar on newly introduced mediation bill by the Government of India is very special for ACCI Mysore Center, as we have taken the lead to disseminate information about this topic among the professional consultants, builders, and developers. I now wish to express our proposed thanks to the two international learned resource persons, Sri B. Rengaraju from International Mediation Institute, Singapore, and Engineer PM Nagesh, Director, Chambers International Limited, Singapore, for the success of this webinar. The speaker have enlightened us on the insight of mediation bill regarding institutional mediation for resolution of disputes, enforce, mediate settlement agreements, provide a body for registration of mediators to encourage the community mediation, and to make online mediation as acceptable and cost-effective process. We are extremely grateful to both the speakers for taking time off their busy schedule and sharing their valuable knowledge on mediation to us. We express our gratitude to both the resource persons and to look forward to their continued interaction with our association in future. I wish to express our heartfelt thanks to Engineer Niranjan Simha, Advisor, Larsen and Turbo, for his closing remarks on mediation bill, which was very apt and appropriate. I wish to state that success of this webinar is mainly due of the proactive efforts of Engineer Niranjan Simha, Advisor, Larsen and Turbo, and Engineer MS Ramprasad, Past Secretary of ACCI Mysore Center. We wish to express our sincere gratitude to both of them for their efforts, meticulous planning, and execution for more than 1 month for making this a reality. Thank you, sir. Sirs. We are extremely grateful to Mrs. Ramco Cements Limited for joining hands with us to organize and conduct this webinar on mediation bill. Our special thanks to Sri Rajkumar, Assistant General Manager, Marketing, Shashank Sharma, General Manager, Technical, and Santosh, Assistant Manager, Technical of Ramco Cements Limited, Mysuru, for making this webinar successful. We thank you for your continued support extended to us. I wish to express our profound thanks to Engineer Anil Pillai, General Manager, Technical Services, Ramco Cements Limited, for facilitating this platform and wonderfully moderating the webinar. Our thanks and appreciation to your efforts, sir. I wish to express my sincere thanks to all distinguished participants from ACI Mysore Center, other centers, Builders Association of India, TRADAI, invitees, guests, and participants from outside India for actively participating in this webinar. Thank you all for your unlimited support and taking part in activity of ACCI Mysore Center. We hope that this seminar provided a platform to all the participants to acquire knowledge on mediation bill, form the learned resource persons, and express their views on this issue. I am sure all the participants agree that information deliberated during this webinar was very informative, relevant, and useful to their profession. I wish to thank all those who have helped directly or indirectly to make this webinar very successful. Thank you, one and all.
Thank you. Thank you so much. Thank you.
Thank you, sir.
Thank you, everybody, sir.
Thank you.
Thank you. Thank you, everybody.
Thank you.
Thank you, all of you. Thank you very much.
Bye-bye.
Bye.
Bye.